All right. Good evening, everyone. Sorry that I'm coming live via Memorex again, but I guess I didn't realize that our nation's birthday was not a holiday here at the uh, Center for Advanced Legal Studies. But I thought today was going to be a holiday, but no big deal. Uh, y'all have this recording. Y'all can watch at your leisure, either here on July 3rd or some other day. Um, with that said, if I do feel bad about not being here live in case y'all have any questions. And if I just have one single person email me and request this, um, I will come on here to Collaborative Ultra and open up the classroom either Wednesday or Thursday. I know y'all have class, but maybe right before y'all's class at 6 or 6:30, and hang out here live so that I can answer questions. Uh, but to be honest with you, you and use you as a class, the entire class have asked very few questions throughout the course of this class. So I'm not going to do it unless someone requests it. And if you're sitting there thinking, man, I hope someone else requests it, just request it. I don't mind doing it. As a matter of fact, I want to do it. But if y'all aren't going to ask questions, I'm not going to sit here in front of my computer by myself, just staring at it, hoping someone will come in. And again, on that same vein, if y'all have questions, y'all need to ask questions. That's what I'm here for. I don't think I'm a big scary dude, and I want you to ask questions. I can tell you that as I've gone through the assignments, it's obvious that some of you have not understood portions of it. And if you don't understand it, the only way to understand it is to ask questions. And again, that's what I'm here for. I want to help y'all. Call me on my cell phone, text me, email me. I will be more than happy to try to help y'all out. On that same vein, if you look, I'm sure you have, you can see that I've done my grading. The last thing I graded was the discovery portion of the class. Again, I was relatively disappointed in the effort in the class. In general, the grades were fairly low, but the reason for it varied. I would say a lot of you, maybe even up to half of you, did not complete the entire assignment. Y'all did the interrogatories, but you didn't do the request for production. You did the notice of deposition, but you didn't quash the deposition. I have no explanation for why that happened. Why did you not pay attention to what the assignment was? Did you not understand something? I've got to believe it's not that you didn't understand it because you didn't ask me questions. So I've got to think that you didn't pay attention to detail as you're doing the assignment. We are an attention to detail oriented profession. You have to pay attention to detail. You have to do the entire assignment. There's a portion of you who didn't use the forms I gave you. Let me just say that if you were in my law firm and I gave you a form to use and you didn't use it, I would probably question your intelligence and sanity. You better have a good reason for not using the forms given to you. Here in a classroom setting, I will grade whatever you submit, but in a law firm setting, if your boss gives you something and says, copy this, he probably expects it to be copied unless there's a very good reason. Maybe you have a good reason. Maybe you've done some research and the form was wrong or whatever, but you better have that reason. But in general, you need to use the forms that are given. And let me tell you, that's typically how a law firm works. If something comes in, and any law firm that's been around for a while, they will have forms that they use. They'll tell you, hey, this is just like the Johnson file, copy the Johnson file. And they expect you to do that. But I don't know. Like I said, just best practice, not just in this class, but when you're working to use the forms that are given. Also, as you know, you can get back points by redoing assignments. Man, I am slightly concerned in that I think I checked right before I logged on here, and I've only got one old assignment out there to grade. So if you are intending to resubmit these assignments, I do want you to do them semi-timely. I don't want to have 300 assignments to grade on the last week of class. But again, I mean, that opportunity is out there. And when I mentioned that I will come online later this week, if y'all have questions, that can be those questions can be regarding anything, regarding any of the classes. So keep that in mind for if you do have some questions. Like I said, I'm more than happy to come online. I'm more than happy to talk to you individually. Whatever it takes to get you through the class successfully. Okay. And I will say today's class is probably a good class to have on tape, because it's going to be a relatively short class like last week. Probably only going to be in the half-hour long range. So most of this class is just going to be organizing records, or that's going to be your assignment. And so should be relatively easy, I'm hoping anyway. All right, so on to the class. All right, we've signed up our case. We have done some investigation. We've done some discovery. We filed our petition, and we survived summary judgment. Probably the next step in the process is we talk about settlement. Virtually all cases settle prior to trial. I think it's in the 94% range of cases do not make it to an actual jury trial. It's kind of discouraging when you call yourself a trial attorney and realize that almost no cases actually go to trial. But the reason for doing all the work to get to this point is, I can guarantee you, if you're not ready for trial, that's the case is going to go to trial. So you want to always be getting ready for trial, even though the odds are greatly against you going to trial. There are several different methods of going through a settlement process. Obviously there's informal settlement techniques, where you just pick up the phone and talk to the other side. But as far as the formal process, we have a couple of different options. First would be in a summary jury trial. That's where you hire a jury. You go through some temp agency to bring in anywhere from 4 to 12 jurors, and you present your case. It's a little bit like the show Bull on TV, which my wife loves, which I will tell you I view as a comedy. Has essentially nothing to do with how the practice of law is, but like I said, my wife likes it, so I end up watching more of it than I probably should. But you have your jurors there, and each side will, or not each side necessarily, although you could have each side present a little brief summation. Depends on how much money you want to spend. Maybe you get an hour and you present your case, and sometimes you'll participate with the other side. Sometimes you'll just have another attorney present the other side's case and get the jury to tell you what you think. Like whenever I do this, which is rare because this is very expensive. It's nothing to spend $10,000 to $15,000 on this process, so it has to be a fairly substantial case to make it worth it. But I like to present the other side's case to help me understand my own case. Like they say that you have to understand the other side before you can really understand your side. But like I said, you get a perspective of some independent people on what they think about the case, and can help you go forward with your settlement negotiation. We also have arbitration. I'm sure virtually all of you have heard about arbitration, and I would say virtually all contracts nowadays have an arbitration clause which require arbitration, and that's where basically you're required to go before an arbitrator. Could be anywhere from 1 to 3 is a common number, might be as many as 5, and present your case, and then the arbitrator makes a decision. And then whether or not it's binding or not, if it's binding, you're required to abide by the arbitrator's decision. And if it's non-binding, it's exactly that. It's non-binding. It's just an advisory opinion. The only real time that you see this typically is if there's an arbitration clause in a contract. You don't really see this too much in non-contract situations. But and I will tell you that arbitration clauses virtually universally are enforceable. Many people try to get out of arbitration clauses, and they're virtually all unsuccessful. Typically, if there's an arbitration clause, you're going to be going to arbitration. Virtually impossible to get out of. You can also go to something called a moderated settlement conference, which is a lot like arbitration, where you just kind of go forward and each side presents their case. Typically, the person in charge, rather than being an arbitrator, is normally it's attorneys who have experience in whatever area of the law that the case is in. And then after hearing both sides, they give their opinion on the case, on good case, bad case, how much it's worth, what the potential settlement value is, and then you can go forward with settlement negotiations. This can be useful when one side or the other, whenever you have very different views on the case. Sometimes you'll go forward and one side thinks it's a $10 million case, and the other side thinks it's a $10,000 case. And so obviously one or the other of you is probably wrong. So basically, you go to some other people who have some expertise, and they can try to steer you in the right direction. And then last but not least is mediation. Probably the most important one up there, and what we're going to talk about for the rest of the class. Virtually every case, not just in Texas, but in the United States, is required to go to mediation before trial. This is where you sit down with the mediator, and the mediator attempts to reach a settlement. Every mediation is different, but typically you give kind of a brief opening, in the order of 15 to 20 minutes each. And then you sit in different rooms, and the mediator goes back and forth trying to reach a settlement. And the sole goal of the mediator is to help you reach a settlement. It's not to determine what's right. It's not to determine who's going to win. It's just a simple matter of, will you pay this and will you accept this? And like I said, I would say all cases in Texas are ordered to mediation. If it's not all, it's very, very close to all. Even cases that are not appropriate to mediation. I do a lot of workers' comp law, and most workers' comp cases cannot be settled in Texas. But even though by law you cannot settle them, and so even though you cannot settle, the court still ordered me to mediation, and it's just kind of a waste of time and money for everybody. So when I get those mediation orders, I've got 10 days in which I can object. You can see there, that's under the Civil Practice and Remedies Code 154.022. I will file my objections to mediation. I'll explain to the court that the workers' comp case cannot be settled, but even under those circumstances, I have still been ordered to mediate, even though by law I cannot settle the case at mediation. Everything that happens at mediation is confidential, and you cannot take the deposition of the mediator. You can't call them to testify at trial, about something that's said at mediation, things along those lines. But the point of objecting to the mediation is that it is virtually impossible to get out of mediation. The courts want you to go to mediation. If you think about it, with 90% or more of the cases settling, that's less work for the judge. Take the short view of it. But, every time you settle a case, that's something that the judge doesn't have to do. But you can file a motion to object to mediation, but unless you have some sort of very, very good reason, you are not going to be successful. The fact that you don't think it's going to settle is not a good reason. It has to be a real legal reason. The important thing and what you're going to be doing as a paralegal, not just for this class, but once you get out there in the profession, is you're going to be getting the file ready to mediate. The first thing that you got to do is have the person that has the authority to settle go to mediation. Now, sometimes you think that's going to be easy. Maybe in our case we have a plaintiff. We have one individual, and pretty easy to know who has that authority to settle. But I can't tell you how many times I've been to mediation, had my client there. The next thing you know, they got to call mom, they got to call dad, call the wife, whoever. If those people are going to have to be there to give their opinion, let's get them there and have them there all day. Because sometimes it's hard to get hold of people, and if they have not been there all day, they don't have the proper background in which to give an opinion on the settlement. So let's get them there. Other times it could be a little bit more difficult. You represent a corporation. Who has the actual authority to settle? Is it vice president, president? Is it some manager? Whoever it is, get them there so that you can actually settle the case. And got to ask questions and make sure that the person that's coming has the authority to settle. It doesn't do you most mediations, it seems, last 10, 12, 14 hours long. Frustrating to sit there for 10, 12 hours and then find out that the person sitting there doesn't really have the proper authority to settle, that he's got to call somebody and make sure. It can be very frustrating. Prepare a mediation memo. Oftentimes the mediator wants this. Me as an attorney, I don't really need this. I'm not familiar with the case, but you got to remember that The mediator, the first time that he hears anything about this case is when you walk into his office that morning. So most mediators nowadays, they want just a little, one-page statement on what the case is about. This auto accident. So a lot of mediators will have a form for you to fill out. Has there been any settlement negotiations, that type of thing? Are there any outstanding discovery type issues? What I do like to have at mediation, what I have my paralegals make is just a little notebook. It's a little 3-ring notebook. Is I want the deposition summarized. So a lot of times at mediation, you're sitting there making arguments, and it becomes a he said, she said type thing, unless you can actually point to the facts. So rather than having to flip through depositions for 2 hours looking for something, if I already have them summarized, hopefully I can find it quickly. Same with damages. Need to know how much the damages are so that I know how much to ask for at mediation, how much to offer at mediation. Need to know how much those damages are. And I also need to know, are there any liens against my case? What a lien is, or these others, is subrogation interest, which we'll talk about here in a little bit. Is these are people that have to be paid out of the case before I make any money or my client makes any money. So very obviously, very, very important to know that. Would stink to settle the case and then find out that we've settled it and we don't get paid because we have to pay all these other people. So a deposition summary, it doesn't have to be complicated, but this is what I like when you go to work out there for an attorney. They may like it a different way. You just got to match whatever your attorney is. Again, when you're told how to do something for your boss, you have to do it the boss's way, not how you think it is. But this is how I like it. I like to have a brief paragraph. And whenever I say brief, I mean brief. I don't want some 4-page deposition summary. I want a paragraph, 2 paragraphs. I want it to sit on 1 page. Things are moving quickly. And first of all, remember that I was probably at this deposition, so I don't need a whole lot of information. But even if I wasn't, I need, out of probably 99.999% of all depositions, it can come down to about 3 or 4 facts that are really important out of that deposition. So here I have my my deposition summary. Again, it's just a paragraph. Apparently, this guy was an eyewitness. He's a colonel in the Army. Again, very, very important for credibility. If you have to have a witness sitting on the stand, having a colonel in the Army is probably about almost as good as it gets. He saw the defendant talking on the cell phone while driving. Very important fact, and that he had an opinion as to who caused the accident. So we may be sitting there in mediation, and the other side says, "Nah, he didn't say that the defendant was talking on her cell phone." So got to go through the deposition and find her, find where she actually said that and show the mediator. So after this paragraph of the summary, I then like page references. So if I have to know, I have to look up, all right, she's talking on her cell phone. I look down, see, okay, that's on page 7. I can turn to page 7 of the deposition, show the mediator, here's where he said that. So again, here's how most of my, not most, this is how I like my deposition summaries. A little brief paragraph followed by line and page numbers on where I can reference the important points to the deposition. Okay. Remember, you're going to be doing this for class tonight. Then I want The next tab in my notebook, y'all aren't going to be preparing an actual notebook. You're going to be turning it in online, but in reality, this would be in like a 3-ring binder. I want my damages summary. Again, damages are important. This is what we base how much our settlements are for. I want a brief paragraph on what her medical treatment was, or if we're talking about a personal injury case. I want to know, did she have surgery? I want to know, what her diagnosis was. Did she go to the hospital? Things along those lines. For lost wages, I want to know, what type of wage earner she was. Here, she missed 112 days at $12 an hour, and then total it for me. Same with the medical. I need to know how much the medical is. So here's my brief, my damages summary, and this can be either in a paragraph. Sometimes this will be in bullet points. Like here, it's important to know. We've got a herniated C2, C3. And then we got a disc fusion, and something here that's important to know. When you're reading medical records, which you are going to be reading medical records tonight, you're going to have to understand them. Okay. Sometimes it can be look like Greek, but I know when I started, especially, but even now, as I read medical records, I sit there with a copy of the medical dictionary beside me, or I have Google open so I can figure out what's actually happening. So you have, if you don't understand it, it's hard to summarize it. So as you read it, if you don't know what a herniated C2, C3 is, you need to Google it. For those of you that don't know, C2, C3, that's the cervical vertebrae in your neck. And if you herniated it, it hurts. I can tell you, and you're probably going to have surgery, depending on how bad the herniation is. But you may need to look, see, does the doctor relate this to degenerative changes, which means basically getting old, or do they relate it to the accident? It's important to know. But just like my my deposition summary, after my damages summary, I want a chart. I want my medical billing summary. I need to know how much these are. Something here important to note when I'm totaling them. Whenever I got down here to my total hard damages, notice I want to know how much was paid, which is 50 grand, plus the lost wages to get this. It's not how much was billed. There is a difference. If any of you have health insurance, you know that they typically have negotiated some sort of lower or reduced amount. So the hospital may bill you here, City Hospital billed $17,000, but the insurance company only paid $3,000. There is a difference. The difference is that in Texas, you are only allowed to recover how much is paid. That's in the Civil Practices and Remedies Code here. I'll cite it to you later. But when you're coming up with hard damages, you need here the amount paid. Excuse me. Then here we have a bill that was denied by Dr. Cutter. Since the insurance is not involved in that case, we need to add that back. So here we have $5,500 was actually paid. And then for hard damages, though, we have to add back in that amount that insurance denied. So we have total hard damages of $50,000 in this particular example. I like these split out by how much was billed versus how much was paid. And that's due to the Civil Practice and Remedies Code here, 41.0105, which limits how much you can recover in a personal injury lawsuit. It limits you to how much was paid by the insurance company. So to go back, because of that law, if I'm trying to get money here for, say, the ambulance bill, I cannot recover $1,500 for the amount billed. The most I can recover is $500. That's why I need to know both. So my next tab in my notebook is going to be liens. Again, are there any liens on the case that I have to pay back out of any money that comes in? Your client's sitting there, he's going to want to know how much money is going to go into his pocket. He doesn't matter to him if you get in, say, $100,000 offer, but he's going to get $2,500 out of it because of the various liens. You can have a bunch of different liens, insurance liens, government type liens, if they have Medicare, Medicaid, hospital liens, and your letters of protection. Important thing to note, your government liens and workers' comp liens, they have to be paid. That's in the law. They don't even have to tell you that they have a lien. You have a duty to investigate the lien. So typically for work, you should be able to know this. You should be able to look at the medical bills and see, okay, who's paying this? Was it on the job injury and workers' comp is paying for it? Is Medicare paying for it? It should be relatively easy to figure out. But one thing to note here is that us attorneys, if we have a government lien out there, if we have, say, a Medicaid lien, and we don't pay Medicaid back, we have to pay Medicaid personally out of our pocket. So trust me, we try to always check and make sure that if Medicaid's involved, that we pay them off. I've never had to do it, and hopefully I never will, but I can't imagine, sitting here settling the case, giving my client the money, and then finding out, a year later, 2 years later, however long, that I have to cut a check to Medicaid because I didn't do a proper investigation, or my paralegal didn't do a proper investigation. So you always want to check and make sure if there's any government liens. Health insurance liens. Virtually everybody has some form of health insurance. Typically, however, and typically in those, they will have a subrogation clause. You may not know it, that's in there whenever you agree to have health insurance, that you agree that to pay them back any subrogation interest. The difference between a health insurance lien versus a government lien is that we as an attorney do not have to pay them back. The client has to pay them back. The only time we as attorneys may have to pay them back is if they have put us on notice. So a lot of times they will, your health insurance company will send you a letter saying that they have a lien on the case. And if they do that, you cannot forget about it. You gotta put it in there and take that into account, that they are wanting their money back for the monies that they have paid. You may also have letters of protection out there. What a letter of protection is, and I'll show you an example here in a second, is basically where you have a healthcare provider who maybe insurance hasn't paid, like we just showed you there with Dr. Cutter, and you reach an agreement, or the attorney reaches an agreement with Dr. Cutter and tell him that, hey, I don't want you to start collection proceedings against my client. I will pay you your bill when we settle the case. So again, for my tab in there, I want my lien information. I just a little brief chart. Here in this particular example, I've got a workers' comp lien of $20,000. You can see here I have the date. I want to know, is the date current? Are we looking at a 6-month-old no amount? Although it's always going to be current, because you as my paralegal are going to call the week or so before mediation and make sure that it's current. I may need to talk to someone about the lien, so I need the name and the phone number of the adjuster. Again, this is stuff that I need in that tab under my lien information. So here we also have a letter of protection, and how much it's for, and my contact information for Dr. Cutter, who has the letter of protection. So pretty simple. You should know most of this information going in. It's just a matter of keeping it updated, and that's why I like to have those dates on there. Here's our sample letter of protection. This is going out to the doctor. This just says that and remember, this is coming from me. I'm signing this letter. I will pay your office outstanding medical expenses out of any settlement proceeds. I'm not personally guaranteeing this. I'm just saying that I personally guarantee that I will pay it out of the settlement proceeds. So obviously, very important to know about. If I've signed a letter of protection and then I disperse settlement proceeds without paying it, this is a contract between me and that doctor, and I'm in breach of the contract. So I potentially would have to pay. Again, if my paralegal has lost a letter of protection, you can imagine I'd be very upset with my paralegal. So you have to keep track of this. Usually, whenever I send this off, I ask for a copy of the medical records and bills. So here in this third or fourth paragraph, I'm asking for a copy of his file, basically. Good practice to do here is have your client sign it, and he has to know that you are entering into a letter of protection with this doctor. He has to know that this doctor is going to get paid. So you'd be amazed sometimes that you get down to settlement time and you start paying off these letters of protection. Your client says, "Hey, you know, why are we paying Dr. Cutter, $40,000? This is my money." And this is where you can bring out the letter of protection and say, "Hey, we told you about it. Here's your signature on it. He deserves to get paid back." So that's how letter of protection works. All right, for your next assignment, I've provided you a deposition and some medical, which I want you to summarize for me. I've also need you to do me a letter of protection to Dr. Cutter, and that's for, let's say, $40,000 that we're sending it to Dr. Cutter. So again, these are real medical bills. This is a real deposition that I need you to summarize and do it in the format that I provided for you. So hopefully this is a relatively straightforward assignment. Now again, if just one person emails me and says that they would like for me to come online either Wednesday or Thursday, like I said, it'll probably be right before y'all have class. So say 6 o'clock on Wednesday or Thursday, 6 or 6:30. I will come online to answer questions. Otherwise, you can email me, you can call me, you can text me, and any questions that you may have regarding this assignment or any assignment, or even about life in general, if you like. But again, this is what I'm here for. So good luck. I hope that you'll have a happy 4th of July. Eat a bunch of hot dogs. Throw up some fireworks. Whatever makes you happy. I hope y'all have a good time.